I think we can kick off. So welcome to all the joined and thank you for your time. Today is the second snapshot being hosted by Primerio on African jurisdictions, covering inter alia competition law developments. So just to ensure that today's snapshot runs smoothly, please will everyone ensure that their cameras and their microphones remain off until the end of the session, which is when we'll be conducting the Q&A if there are any questions. The speakers for today's snapshot include Rostom Omar, Gina Lodolo, and myself, Nicola Talyaard, all from Primerio Law Incorporated. So by way of brief background of Primerio, we are a Pan-African law firm with our head office in Johannesburg, South Africa. We also have a regional office in Kenya as well as in Mauritius. And then we also have strategic partners in several key African jurisdictions, including Rostom, who's based in Egypt. Our primary focus is on competition law, including cartel investigations, merger control, abusive dominance complaints, foreign direct investment, market inquiries, and the like. Although it's not particularly relevant for purposes of today's webinar, we also offer white-collar crime, general commercial, trade, and regulatory legal services. Let me now hand over to Gina, who is going to give us a brief background of Egypt's merger control regime.
Thank you for that introduction, Nicola. So by way of brief background, the ECA has increasingly become more active, and following almost 2 decades since the introduction of the Egyptian competition law having a post-closure notification regime, the Egyptian Competition Authority has now introduced a pre-merger control regime for transactions meeting certain conditions and requiring approval from the ECA before the transaction can be implemented. This follows the ECA having raised a number of concerns about potential anti-competitive impacts of certain transactions in recent years. So this new law proposes a significant shift in the Egyptian merger control regime. And before this proposed amendment, Egypt was the only country in the region and one of the few countries in the world without a pre-closing regime. So before Rostom gives us his insights into these amendments, Nicola, could you run us through the old merger control regime? You're on mute, Nicola.
Sorry, my apologies. Thanks, Gina. So as you mentioned before, the amendments, most notably, they had a post-merger notification regime, which required notification post-closing within 30 days from the date of implementation. So post-closing, the transaction would have to be notified if the thresholds were met. So in this regard, the ECA had to be notified if the combined annual turnover of the parties involved in the transaction exceeded 100 million Egyptian pounds. The law, however, contained no express definition of what constituted a change in control. Rostom, we understand that the new law provides for strict standstill obligation in instances where the definition of economic concentration is met. What does this definition cover, and can you walk us through the amendments and whether the amendments clarify the element of change of control?
Thanks, Nicola. Thanks all for being here. And I would like to make a special thanks to my friend, dear friend, Mr. Mahmoud Dawa. He's one of our experts here in Egypt in the AML, which is the other part that we're. Let me just, before starting this,
Thank you, Mr. Rostom.
Thank you so much. So let me just start to add something concerning the old Egyptian regime, the old notification regime. Can I add something before I go through the new amendment? That in the beginning, concerning the notification form, ECA was opening, widely to accept any notification since it was a post-notification system, first of all. But and on the second hand, was trying, especially during the recent years, trying to catch any kind of M&As that could harm the competition. And one of them was the most famous of these examples was the car hailing service, since ECA made already a case in such service. And was stopping the merge for a long time till it accepted in the end. One of them also was one of the biggest during the last years was in the medical sector between two huge giants working in the medical sector. And it stopped that, and it was making through the tools that it have in the law, in other articles, trying to cover or to stop such mergers and acquisitions, such that in the medical sector, and it made already some arrangements with the Ministry of Health trying to stop these kinds of mergers unless before its acceptance. So that was just a glimpse on the old regime. Concerning the new amendments going through ECA, the new regime for already envisions a pre-closing clearance procedure. In addition, the amendment now define an economic concentration as any change of control or material influence, right, on one or several entities that may result of traditional mergers and acquisition. So ECA used now through the new amendments the control and the material effects. Control simply, let's say that it's the effective ability to influence directly or indirectly another person's economic decisions. Let's put it that way. And the amendments treated the material effect as it's also a direct or indirect, the ability to directly or indirectly influence the policy of another person, such as a strategic decisions or its business goals. And the article treated the three forms of economic concentration, which is merger, as we know, acquisition, and joint venture. If I may add here just one thing also, that the amendment treated also that what it's not considered an economic concentration. So the new amendment treated that way, that there is two things. First, the internal restructures in the companies, if it's an internal restructure in the companies through a merger or acquisition in the same group or the same relevant persons. The second is the companies who are operating in securities. If they resale such securities or shares within a year. Otherwise, they have to add more than 1 year. They have to ask for permission from ECA to extend this period. Hope that covered this part.
Yes, perfect. Thanks, Rostom. So turning to the second step of the test being the thresholds. Before a merger is notifiable, thresholds will still have to be met, and these have also been subject to amendment now. So the previous thresholds presumably did not exclude foreign transactions, as one party could effectively meet this threshold, as it looked at the turnover total of all of the parties' turnover. So effectively, an acquirer with a high turnover could still meet this threshold alone, although they still needed to be in a fixed test on the market in Egypt. So in this regard, where the threshold was met, mergers would still be notifiable, where the merger was likely to distort, restrict, or harm competition in Egypt. So Rostom, can you walk us through this new threshold amendment and explain whether the new thresholds go some way in potentially limiting the threshold to exclude foreign-to-foreign transactions?
All right. So an economic concentration will be notifiable with the new amendments as follows. The combined turnover or assets of the concerned undertakings in Egypt in their past fiscal year, if that exceeds 900 million Egyptian pounds, provided that each of at least two relevant undertakings has an annual turnover exceeding 200 million Egyptian pounds during the past fiscal year. So this is the first element. Second element is, sorry?
No, I just think go.
Okay. If the global combined turnover or assets of the concerned undertakings in their past fiscal year exceeds 7.5 billion Egyptian pounds, provided also that at least one party to the transaction has an annual turnover in Egypt exceeding 200 million Egyptian pounds during the past fiscal year. And again, here there is also the way of calculation. It's already referred to the executive regulation about this calculation.
So, Rostom, from what you've explained here, for purposes of notifiability of foreign-to-foreign transactions, it appears that the acquirer alone would still be able to meet this test because the second test is not limited to the target in Egypt. So could you explain whether foreign-to-foreign transactions are still notifiable on this basis, or whether there would be a basis to exclude a transaction on the fact that there are no effects, or whether there's a lack of a local nexus?
Okay. To answer this, I have to go through many points that we have to put it into consideration. Like, first of all, in the same article, in the new amendments, there is a part that said that in all cases, ECA has the right to examine, of course, after the board acceptance, any economic concentration, even if it's not notifiable. So it have the right to examine these M&As if it has an evidence or a presumption that it would harm competition within a period, which is important, that not exceeding 1 year past the date of implementation. So we have to put this into consideration as a matter of fact as the beginning to base on, and also it's referred to the executive regulations again. So now we see the scope of the powers of the ECA powers to do that. Second, we have to look about the extraterritoriality mentioned in the law in Article 5, which is also was the power of ECA to search and examine if there is a harm to competition, to the competition in the Egyptian market, even if it's abroad. So this is the extraterritoriality effect. And again, also we have to put into consideration Article 20 about the remedies and the elimination of the breach, that it's already stipulated in the law that ECA could use. And in the same time also this article has amended recently with the new amendments. So now the M&As entered already into the application of Article 20, which is, as I said, the remedy and the elimination of the breach, but also in the end, ECA has the power also to consider the agreement in breach void and null. So this is another thing also to put into consideration. I can add one more thing, that the ECA approach in such cases, which had already usually do before, and even during this the recent years before I call it the mid years, when ECA was when we was dealing with ECA in M&As in that time, ECA has created already a new application form for the notifications, where it added already all what it needs to calculate and to deal with the parties, the relevant parties to the M&As. And the ECA approach in general, which was widely open to accept these kinds of mergers. So we have to put this into consideration. And of course, we'll be waiting for the executive regulation to see what ECA will do exactly, what will be the new approach. Finally, I would say from my experience, from even in other jurisdictions in such countries where in the beginnings of applying the new amendments concerning having an M&As control regime, usually in the beginning it goes through a wide open approach, you know, to deal with these such M&As, and then maybe with the workload and the experience more and whatever, and we saw that in other jurisdictions, then it starts to a little bit minimize this and to accept some of these M&As with some rules or guidelines that maybe we'll see it one day with ECA.
Thanks, Rostom. Those are definitely very useful inputs. Do you think there are any other salient amendments that potential merging parties should take note of? And perhaps you could walk us through the timeframes for anticipated clearance, whether there are any filing fees payable, and the penalties if parties implement the transaction before they've notified.
Great. I'll tell you, it's like in many other jurisdictions as well. ECA has 2 ways of examinations, which is the normal examination, which takes 30 working days after the completion of the notification file. And this could be extended for another 15 days if the parties has presented already their another obligations or whatever, if there was something that makes some raised doubts to ECA, and then it will be extended for another 15 days. If ECA has shown some doubts that there will be harm to competition, that it will be referred to another phase, the profound examination, which is the second phase, which is for 60 days after the referral, and could be extended for another 15 days. This is concerning the duration and the examinations, like two phases for examination and the procedures. The procedures goes through the board each and every time, will choose the committees. These committees are responsible, to examine the notifications. However, what we can give also a brief on, we can talk about the fees. The fees, the maximum of the fees will be defined as 100,000 Egyptian pounds. And we're still waiting also for the executive regulations to give the idea about that, because this is a general article treating the fees for this and the fees for other requests from the ECA. But anyway, for the M&As or for the notifications, will be the maximum is 100,000 Egyptian pounds. We can give also a brief on the penalties. I guess you mentioned it, Nicola, I guess. The penalties will be almost the same amounts as for the dominant position fines, and Article 7 also, the vertical agreement, which is starting from 1% from the annual turnover till 10% of the annual turnover, or the assets or the value of the operation. 1 to 10%. And in case that it cannot be calculated, then it will be from 30 million Egyptian pounds, not exceeding 500 million Egyptian pounds. And we don't forget the other penalties, as we mentioned before, such as considering the agreements void, besides the other corrective measures and whatever. I guess that's it.
Thank you, Rostom, for your insights into these really important amendments. So finally, and perhaps the most important part of this webinar, there's been much talk about whether these amendments are actually enforced, and as the regulations aren't yet to be promulgated. So Rostom, in your experience on the ground, where to from here for parties determining whether they should be notifying their transactions pre-closing?
All right. Because of all what I mentioned, especially this idea of the powers of ECA, I guess the position will be that way. First of all, or let me start first of all by saying that the new amendments cannot be implemented on the ground now, because there is no executive regulations. And as you saw when we go through most of the law, when we are talking, I'm telling you, stop, we're waiting for the executive regulations, stop, there is the calculations, the method, how. So it all will be postponed till the executive regulation. And I know that ECA does not apply the amendment up till now because there is no executive regulations. That's what I'm sure about. From my experience with ECA and my ex-colleagues, and from what's going on, what we do on the ground here, is that it's recommended, if there is an M&As now, and I'm in the process of, that I do go to ECA amicably now, on friendly basis, to talk with them on it and start to work and complete our deals or our agreements as it is. Because maybe in some times, before finishing the deal, the executive regulation shows, and if the executive regulation shows, there will be a problem that then I'm gonna have to start again from the beginning and start to prepare the whole file and go to ECA from the beginning and starting from the scratch. So I prefer to go to the ECA starting from the beginning on a friendly basis and start to see with them how to go. And if the executive regulation didn't show up, and I'm telling you from what's going on the ground now, from our experience with different parties that are in the middle or ending their agreement, that we go with them and we'll take it from there after the ECA and work solely. If the executive regulation didn't show up, well, great, everything will be fine. And that's it.
Thank you so much, Rostom. I think if anyone wants to ask a question, they can raise their hand now. But in the meantime, thank you very much for your time. I think that concludes today's snapshot on the amendments to the Egyptian merger control regime. Needless to say, the amendments have definitely been robust and they've provided substantial food for thought for any firms wishing to engage in transactions that trigger notification in Egypt. So I see no hands have gone up. So thanks again to everyone that has joined. For anyone that would be interested in listening to this snapshot again, we'll be making a recording of it available on LinkedIn.